आपण स्टार्ट करीत आहोत. सर्वांना पुन्हा एकदा हॅलो, गुड मॉर्निंग. सर्वांचा संडे आहे आज आणि आपण या संडेला आणखी जास्त उत्साही करण्याकरिता आज एक सेशन्स घेऊन आलो आहोत. दर से हमदर्द तक या संस्थेच्या वतीने आज जजिंग रियालिटी संदर्भात रील विरुद्ध रिअल क्रिमिनल ट्रायल्स या संदर्भामध्ये आपण एक सेशन अरेंज केलं आहे. या सेशनमध्ये आपल्याला रिअल क्रिमिनल ट्रायल या कशा प्रकारे चालतात आणि रील क्रिमिनल ट्रायल या आपल्याला वेब सिरीज आणि चित्रपटांच्या माध्यमातून कशा पद्धतीने दाखविल्या जातात याबद्दल गाईड करणार आहोत. आणि मी ॲडव्होकेट सृष्टी भाताणकर पवार आपलं या सत्रामध्ये सहर्ष स्वागत करीत आहे. तर वेळ न घालवता आपण आपल्या दर्द से हमदर्द तक या संस्थेची ओळख करून घेऊयात. आणि आपल्या संस्थेची ओळख करून देण्याकरिता मी ॲडव्होकेट प्रेम मिश्रा सर यांना प्राचारण करू इच्छिते. सर, प्लीज आपण आपल्या संस्थेची ओळख करून द्या.
Am I audible, Shruti madam?
Yes, sir.
Good morning, one and all. Good morning, Ashish sir. I am Prem Mishra. Sir, Dar Se Hamdard Tak organization is working to provide free legal aid. So we believe, and many prisoners often say, that jail is not a jail for those who have money because they can have everything there. But the one who don't have money, it's vulnerable for them. Sir, the work of this organization is going on with the feeling that no one should be deprived of justice due to lack of money. So Dar Se Hamdard Tak Sanstha is working not only to release the prisoners from the jail, but it makes them to meet their relatives. So we so far, Dar Se Hamdard Tak organization, we have filed bail application of 50 prisoners and more than 200 to 300 plead guilty applications for more than 200 to 300 prisoners have been filed and approved in the similar courts. So various representatives are working relentlessly and passionately to turn the aim and will of this organization into reality. So recently we have succeeded to get the bail of the murder accused who was under the judicial remand in Mumbai Central Jail for 2 years. So in this particular case, our organization brought into a kind attention of the court that the deceased died not due to the assault of the accused, but he died because he was having a pre-existing long-term illness. When it was brought onto the record of the Honorable Court immediately granted him the bail and discharged him on the liberty. So I would like to briefly mention that how our organization is not only working on the district chambers, but also putting its footprints on the state level as well. Sir, one of our esteemed volunteer took efforts to desk the petition before the Honorable Bombay High Court. And the matter was that the Directorate of the Prosecution, it means the organization that controls the public prosecutor, had their motto and the slogan to class maximum conviction in criminal trials in its policy. And this slogan and motto is also reflected on their websites. So we filed a public interest litigation in the Bombay High Court, and Bombay High Court directed the concerned organization to change their said policy and the motto. So thereby they change their motto and the policy and they turn it into to conduct a criminal trial fairly and assist the court in discovering the truth. In this way that we are assisting the courts not only on the district level but also on the state levels. So there is a new debate that arose before the parliament regarding the age of the marriage of the girl, which later became a matter of consideration for the government as well. We even assisted the government at what should be the age of the girl child for the marriage and what could be the legitimate way out for it. So a legal opinion was also given on behalf of us on what should be done on the marriage of the girls. So there was an issue that a former commissioner of police of Bombay had issued a circular regarding the registration of the POXO crimes. So that circulation allegedly used to say that no case of POXO should be registered without the permission of the higher officials. When this particular circular was promulgated and was circulated, our Dar Se Hamdard Tak organization took a prompt action and we made an intimation to the commissioner and the home ministry that that particular circular was being illegal and out of jurisdiction of the commissioner's power. So later the circular was withdrawn and the earlier law was set into the motion the way it was. So another issue that was being carried out in public at large and where our assistance was being asked was regarding the e-governance. So when the e-governance issue was raised and when our opinion was being sought, we made an opinion, Dar Se Hamdard Tak Sanstha made an opinion with a letter to the government in order to implement the e-governance on various prisons in various prisons of Maharashtra. And as a result of this, e-interview has now been initiated, where the parents, the family members, and the lawyers can conduct the interview of the jail inmates virtually. We are not only working only on the basis of to grant the assistance of the legal aid to the prisoners, but we are also working to create a legal environment and a lawful environment in the courts as well. So we came across a very traumatic situation where we saw that when we visited a Thane Central Jail, one of our correspondent noticed that a lady lawyer informed one of the murder accused that he has been granted with a bail, and she provided a forged copy, a forged signature, a bail order of with a forged signature of a judge to that accused. So for many months, he was under the impression that he has been granted with a bail, and ultimately he approached us for his bail furnishing. We promptly wrote a letter to the commissioner of the police and requested them to immediately register a case against the lady lawyer, and thereby it was registered. Sir, a free legal aid advice house camp has also been organized recently at Sambhajinagar, and through that we have also provided free legal advice to many people. Also, through the organization, we succeeded in getting jobs for the prisoners so that they can get their hands working after getting on bail and after being released from their case. Sir, we firmly believe that we owe the faith of many. We owe the faith of judicial system. We owe the faith of judges. We owe the faith of accused. We owe the faith of relatives, the faith of the jail system, the faith of society. Sir, we have started working on various phases and still crave to work on various phases. Thank you, sir. Carry on.
थँक्यू प्रेम सर. तुम्ही खूप छान पद्धतीने आपल्या संस्थेची माहिती दिलेली आहे आणि आपल्या संस्थेच्या कामाचा आढावा सुद्धा दिलेला आहे. तर आपण पुढच्या ला सुरुवात करत आहोत. आपण नेहमीच वेब सिरीजमध्ये, चित्रपटांमध्ये ऑर्डर ऑर्डर, ऑर्डर सस्टेंड आणि ऑर्डर ऑब्जेक्शन ओव्हररूल असे शब्द अनेकदा ऐकत असतो. कोर्टरूममध्ये भरपूर मनोरंजक पद्धतीने ड्रामा सुद्धा सुरू असतो. परंतु हे सर्व क्रिमिनल ट्रायल्समध्ये होत असतं आणि रिअल क्रिमिनल ट्रायलमध्ये दोन्ही वकिलांचा युक्तिवाद ऐकला जातो, साक्षीदार, पुरावे ह्यांचा अभ्यास केला जातो आणि ह्या आणि रिअल क्रिमिनल ट्रायल मधला फरक सांगण्याकरिता आज आपल्या सोबत ऍडव्होकेट आशिष चव्हाण सर उपस्थित आहेत आणि आशिष चव्हाण सरांचा थोडक्यात परिचय करून देण्याकरिता मी आपल्या संस्थेचे विवेक निषाद सर यांना विनंती करत आहे. विवेक निषाद सर, तुम्ही सरांचा थोडक्यात परिचय करून द्या.
Hello, am I audible to all?
Yes.
Sir. So hello and good morning and a warm welcome to one and all present here. My name is Vivek Nishad, and I assume that many of us present here in this session belong to the field of law and very much excited to proceed with this session. But before we proceed further, let me take this opportunity to introduce our chief guest, our guest speaker for today, Advocate Ashish Chavan sir. Sir is someone who needs no introduction in the field of law, but he is someone amongst the stalwart achievers of the legal field. So today, I'm very privileged to share with you some of his professional milestones and achievements. To begin with, Sir has appeared in more than 100 matters, mostly on the criminal and constitutional side, before the Honorable Bombay High Court since 2000 until date. He has several reported judgments under his belt and now has been a legal practitioner for more than 25 years. Sir has appeared in number of trials before the Sessions Court and Metropolitan Courts, arising out of acts such as IPC, Prevention of Corruption Acts, Atrocities Act, MPID, POCSO, Negotiable Instruments Act, medical negligence cases, etc. Sir has appointed as a special public prosecutor by the government of Goa in the famous Tarun Tejpal trial in the year 2021. He is appointed by the Ministry of Law and Justice as additional public prosecutor for Union of India in the Honorable Bombay High Court and as a public prosecutor in subordinate courts wide notification dated 22/3/2022 for a period of 3 years. Sir has empaneled a retainer counsel for Directorate of Enforcement, Government of India to present the Directorate before the Bombay High Court, wide order dated 8 April 2022. He has assisted former Additional Solicitor General Shri Anil Singh, Senior Advocate, in number of important briefs for Enforcement Directorate, Serious Fraud Investigation Office, CBI, Narcotics Bureau, Ministry of Home Affairs, Ministry of Environment and Department of Control Government for from March 2022 onwards. Sir has appeared in number of matters representing Directorate of Enforcement, Central Bureau of Investigations, and Narcotics Control Bureau, and many such cases. Sir has represented successfully his corporate clients. Some to name them are Reliance India Limited, State Bank of India, Bennett Coleman and Company Limited, Vodafone Isar, Bombay Textile Research, and the list goes on. Sir has appeared in a PIL filed by the activist Pushkar Damle before the Honorable Bombay High Court regarding the functioning of Maharashtra Human Rights Commission in the year 2009 and 2010. Sir has also appeared in a writ petition before the Honorable Bombay High Court, bringing to the light the negligence of the hospital managements leading to framing of guidelines for security of the newborn babies in the year 2009. And Sir is also appointed to the Union of India panel since the year 2002 and has also appointed by the governor as a Senate member of Mumbai University. This is a very brief introduction about his achievements and his uh, qualifications, and I now request Ashish Chavan sir to proceed with this session.
Am I audible to everyone?
Yes, sir.
Yeah. So first request to the organizers that if you can keep the uh, availability of the people who can then unmute their microphones so that they can have we can have an interaction here and not a monologue. So whenever I have any reason to interact with people, they should be able to communicate with me. Is that possible?
Yes, sir.
Thank you. Thank you. So thank you, Vivek. Thank you, Prakash. And thank you for this wonderful opportunity to be able to really have a heart-to-heart discussion with all of you, because that is what it is going to be. This is a non-legal topic in that sense, and a very interesting topic, a topic which is very close to my heart. So when Prakash approached me and said that we need you to talk on this topic, in fact, I was very much grateful, and I was very much happy that I would be able to have this discussion with you. And it is really going to be more of a chat rather than a monologue or me talking to you, because this is something which is close to all of our hearts, all of us who are lawyers or would be lawyers or members of the legal fraternity. All of us have seen real life trials. Many of us have seen real life trials, and all of us have seen movies which show trials in some way or the other. So, without any further ado, basically, I would like to talk about uh, real life trials or trials shown in movies, or rather, what we popularly call as courtroom dramas, mostly in the Indian perspective. Because the reason why I say this is that if you look at movies, Western movies, then there is a huge body of movies that you will find, lots and lots of movies which deal with legal issues, which also deal with very riveting, compelling, must watch kind of courtroom dramas. But today we will not be discussing about them, because it will take more than 2 hours to really do justice to the courtroom dramas which are shown in the Western movies. And more importantly, they are not really relevant for the Indian legal system, Indian legal jurisprudence, the legal perspective that we have here. So that is why I am excluding that from the topic of discussion today. And we will rather focus on the regional movies. I have a very limited, it's not that I am a very great movie buff, I do see movies on and off, but whatever list I have tried to manage from my memory, and some which I have really seen and I was impressed, and those movies which have left a mark upon me, we will discuss on them. And if there are any other movies that you would like to share, and where really there is something worth discussing about, we will discuss about that also. But the purpose of having this discussion is not to discuss about movies. The purpose is that, and this is a question which I'm going to frame right at the beginning of this chat that we are going to have. Do the lawyer watch courtroom dramas? If yes, what is the purpose for watching these courtroom dramas? Is it to learn? Is it just to get entertained? Or is it a mixture of both, learning and entertainment? And what are the take home lessons that a lawyer in the Indian perspective, when he watches courtroom dramas, uh, should have? So, the first movie that came to my mind, in fact, yesterday evening when I was thinking about where to start, I was reminded of a very old movie. It was in the 1960s, and the movie's name is Kanun. I don't know how many of you must have seen it, because this is one generation prior to my generation also. So I also saw it because of a recommendation of a very good friend. And when I just joined this link, I could see a very distinguished senior police officer who's also an author, Mr. Arun Wable. I think if he's online, he will agree with me that that movie is probably the one of the earliest and a very good depiction of the Indian legal system. It is a 1960 movie. It is in color, and the other speciality about that movie is that it is one of the first songless movies. It doesn't have a single song. There is no single song in that movie. What is that movie about? The movie is largely about an argument against capital punishment, and it also has a very interesting courtroom, rather many interesting courtroom sequences. And if you see the movie, I would really advise all, or rather, I would suggest all of you to go and watch the movie whenever you have time. It is available freely on all social media platforms, and it deals a very interesting concept of how much reliable is the eyewitness evidence. What the eyes see and what the mind reflects, is it the same? What you are seeing is, let us say, a particular act. Now, for example, in this movie, there is a case of A identifying B on the basis of his external characteristics, when actually the murder is committed by somebody who is C, who has a similar external or physical characteristics. So, how the eyewitness evidence can sometimes be quite misleading is something which is very interestingly depicted in this movie. It has in the judge's role, I believe it has Ashok Kumar, and there is a defense lawyer, there is a prosecution lawyer, and it's a very interesting courtroom drama. It deals with one more concept of double jeopardy. Now, I believe all of us understand what is double jeopardy. That one man cannot be punished twice for the same offense, as to put it very simplistically. So, can anyone recollect any other movie which deals with the concept of double jeopardy? A very popular movie. The other movie, can anybody recollect? It is Andha Kanun. If I mean, all of us are Amitabh Bachchan fans here, many of us should be rather. So it's a very interesting movie which again deals with the idea of double jeopardy. Andha Kanun, which came much later. So Kanun, this movie Kanun, which was directed or rather produced by B.R. Chopra, 1960, is, I think, a very good benchmark to look at if you want to understand the concept of eyewitness evidence, which can be sometimes misleading. Also, the courtroom drama is not entirely inaccurate. It may have some deficiencies and flaws, but it is not entirely inaccurate. And also, it deals with the interesting concept of double jeopardy. Now, before I move on to other old movies, because I wanted to, create a a kind of a discussion where we talk of old movies, middle level movies, as in some movies which came in the 80s, 90s, and the present movies. So in the old movies, you will find more often than not, you will find jury trials. Now, is anybody aware of what jury trials are? When they were in India and when did they stop, and which was the landmark case after which there was a huge public debate, and because of which finally the jury system was abolished in India. Does anyone know about this jury trials?
Yes, sir.
Yes, Vivek.
Sir, K.M.
Yes.
Nanavati
Yes,
versus State of Maharashtra.
Nanavati case.
Correct, correct. So Vibhav Galadkar has also written 1960 Nanavati. Yes, people do know about Nanavati case. But jury trials basically started with the advent of British in India, the British justice system. They continue to a large extent in US even today. UK, some part of it, yes. But then again, the concept of juries has now, which has the jurisprudence evolved all over the world. People have realized, or jurists have realized, the flaws of jury system. What is a jury system basically? To break it down very simply, there is a panel of odd numbered people. It could be 11 people, 9 people. The reason for having it odd numbered is that there should not be a hung jury. If there is a 5 versus 5 verdict, then it could be a hung jury. So you have normally 11 or 13 odd number of people who are representatives drawn from different sectors of society. One could be a doctor, one could be an engineer, one could be a scientist, one could be a teacher. So the logic of this was, आपण मराठीमध्ये म्हणतो पाचामुखी परमेश्वर. So, or we have panchas, the system of punch. Where does that word punch come from? It comes from the word five. Why five? Because normally in ancient times, from earlier times, people feel that if there is a panchayat, you have 5 people. So when 5 people, independent people, come together and decide about a person, normally they would not go wrong. That was the way of thinking of or the logic behind the jury system. So 11 people, 13 people, 9 people, drawn from different spheres of their practice or their life, would come together and judge a person. Now, how would they judge a person? They would see the entire trial being conducted in front of them. They were obviously lay people. They were not lawyers. So, what was the role of the judge? Now, the jury would see the facts. So, they would see the evidence being conducted in front of them, the examination, the cross examination, witnesses, arguments conducted from both the sides, the prosecution and the defense. Now, they would understand the facts, they would make their own impressions about the facts, and they would give their finding on facts. Now, as lawyers, we know that finding on facts and finding on law are two different aspects. So, they used to be then directed by the judge to formulate some kind of so the judge used to give them a particular proposition that, look here, this is the evidence that you have to deal with, and this is the legal parameter in which you have to operate. These are the ingredients. Let us say it is 302. There has to be mens rea, there has to be intention. Then you have to look at the evidence, whether the evidence is requisite to connect the offense with the criminal, etc., etc. Whatever we understand of criminal law was told to them in easy, understandable language by the judge. They used to appreciate it, and as lay people, they used to apply it to the facts at hand and finally come out with a finding. Now, many a times the judge had the occasion of reversing a finding of fact by the jury. So I'm not getting into all of that, but just to make you aware of what a jury trial is, this is what a jury trial roughly used to look like. Now we come to the famous case of, since we have reached Nanavati, we would come to that famous case. In fact, there are many cases which deal with the aspect of jury trials. There is a very interesting case called एक रुका हुआ फैसला. Has anyone seen this movie? रुका हुआ फैसला. अगर नहीं देखा है तो please जाके देखिए. It's a wonderful movie. I mean, it is something which I saw in my junior days as a lawyer, and it left a huge impact on my mind. It is a very beautiful example of what I would call as forensic persuasion. See, the art of arguments in many books is called as the art of forensic persuasion. How you persuade a person, how you work on his psychology, how you present evidence to him in a logical manner so as to appeal to his reason and finally convince him of a particular thing. So that is a wonderful example of Ruka Hua Faisla. I'll tell you when it came. The year is, I think it was in 1986, and Annu Kapoor has played a role in it. Pankaj, uh, I forget his name.
Kapoor.
Pankaj Kapoor. That's right. The person who played Karamchand. We all know him as Karamchand. So he was a very important character in that. It discusses about circumstantial evidence, etc. I'll come to that a little later. But the reason why I'm talking about Ek Ruka Hua Faisla now is that it deals with the concept of jury trials, since we're talking about jury trials. So we have Kanun, which deals with jury trials. We have Ek Ruka Hua Faisla, which deals with jury trials. In the olden times, there was a movie called Waqt, which also dealt with jury trials. So ultimately, what happened to these jury trials? So if you have seen a movie called Rustam, how many of you have seen Rustam? Most of you must have. It's a recent movie, 2016. Akshay Kumar played the role of a very dashing Kawas Manekshaw Nanavati, who what was his real name? The real name of the protagonist in that movie was Kawas Manekshaw Nanavati, and this case is very, very famous, called as KM Nanavati case. And what actually had happened, the facts of the case were that Commander Kawas Manekshaw Nanavati, who was a very decorated naval officer, was accused of murder of one Prem Ahuja. And the allegation was that Prem Ahuja was his wife's lover. The allegation also was that there was a scuffle and the revolver or the pistol went off and there were some rounds fired, and Prem Ahuja was found dead in a pool of blood. Allegation was that this was a case of deliberate murder. The defense presented a theory that it was a case of culpable homicide not amounting to murder. There was grave and sudden provocation. All of you are familiar with all these things. I needn't dilate on these aspects. So, what was two important things happened with this trial? One, that if you, I don't know, I mean, of course, I was also not around at that time, 1959-60. There was this newspaper called, it was a tabloid, it was called as Blitz. And this newspaper commanded a huge popularity among the Parsi community. And Commander Kawas Nanavati was a Parsi gentleman. And the then editor of that Blitz daily tabloid, one Mr. Rusi Karanjia, used to come out with huge, it was, color supplements, a big everyday reportage on what happened in the courtroom today. And it was something novel for Indians at that point of time. In 1959-60, people used to come in crowds to see the entire proceedings. The two reasons why it was so dramatic and popular was, one, the manner in which the whole thing was done. I mean, the appeal that people had, that look here is a young man who wanted to avenge his wife or who wanted to avenge his own honor, and he went ahead and asked his wife's lover whether you would marry my wife now that you love her. And he said no, and then there was a scuffle and he shot him down. What is wrong in that? That was the general sentiment of the people at that point of time. And this popular sentiment was expressed very strongly in that particular newspaper, and other newspapers also picked up. So what happens? Very interesting aspect again, because again and again we come across the word media trial even now. So I would say that this is one of the first cases of media trial, where media, at that time it was only the print media, in a manner heavily influenced the public opinion to a great extent. And obviously juries are human beings. They were influenced, or the allegation now goes that they were very, very much biased, and they felt that this young man deserves another chance. He should not be punished, although on paper there was overwhelming evidence. So this led to a very perverse verdict, where there was a finding of an acquittal, which subsequently went to the higher courts. There was a reversal of that judgment. But the acquittal was so heavily reported, the acquittal grabbed the attention of everybody, that what happened later did not stay much in the public memory. We all still remember that there was a verdict of acquittal. In fact, Rustam also plays it in a similar way. Of course, Rustam gives it another angle of conspiracy and national secrets and what Mr. Nanavati was trying to actually do for the country, etc., etc. That's another small little narrative which runs parallel to the main movie. But very interestingly, the courtroom, again, we come back to the courtroom sequences. Most of it is, if you recollect that movie, most of it is very dramatic, and that drama is all oriented towards the jury. So if you see movies now, somewhere now again, I tried to research on this because a popular perception is that after the hue and cry, okay, let us first see what happens to Mr. Nanavati at the end. So the acquittal is converted into a finding of conviction. All right, but still the honorable governor pardons Mr. Or Commander Nanavati, and then he leaves India and he has gone. He went to Canada where he passed away. So that was how the case actually came to an end. Now, because of this, the popular perception that people have, or many even lawyers have, is that there were no jury trials after this. But that is not correct. Recently, in fact, yesterday only, I was doing some research. Up to 1964, in West Bengal, there were jury trials. So, but largely you can say in India that it created a huge opinion against jury trials. Because if juries are going to get influenced by all these things and they are going to come out with such kind of judgments, two questions were raised: whether as a Indian society are we mature enough to have juries, one, or secondly, are juries really mature enough to shoulder the responsibility of acquitting or convicting somebody based on unbiased, independent opinion. So this created a whole churning. Ultimately, jury was abolished in India, and that is why, if you really look at films, as somebody who would probably look at legal thrillers pre 1960 and post 1960. So post 1960, dire dire, you will find that you have regular criminal trials, the way we now see them, where there is a judge, there is a prosecutor, and there is a defense lawyer, and then there are witnesses and all the charge sheet and everything, as opposed to jury trials. So up to 1960, 1965, you will have movies which show jury trials. And that is why those movies, if you now really look back and think why they were so dramatic, the reason for being dramatic was, even in real life, up to the stage of juries, the scene was quite dramatic. Lawyers used to make long, impassioned arguments. There was opening arguments, there was closing arguments, there was addressing to the jury. If you look at a movie called A Few Good Men, it's again an English movie, A Few Good Men. You will understand what I'm saying. So there are, in the jury system, there is a long, arguments process where lawyers get opportunity to address the jury, and that is very, very emotional. So all this dramatic phase, I would say, was there up to 1960-65, post which you will, in movies, of course, you will find a lot of drama even thereafter. But in real life, the drama has come down to a level where now you will find that it is a very, very systematic and organized kind of a procedure, where there, I would say, as a criminal lawyer who has been practicing for 25 years, I would say, with all respect and with all humility at my command, I would say that fact is very stranger than fiction. So if you really look at it, there is no lack of drama even now. Drama is there. Uh, Anybody who has practiced criminal law, who has attended remand applications, who has argued very sensational cases, will understand that there is drama still. But the drama is not larger than life. The drama is real, and it is within the procedures of law. So we talked about movies like Kanun, we talked about Ek Ruka Hua Faisla, we talked about Andha Kanun. Andha Kanun deals with the aspect of double jeopardy. And now we come to the post 1960 stage, where the first movie that struck me, and I was, It's a very entertaining movie in that sense. It is called Meri Jung, 1985, Anil Kapoor. Now in Meri Jung, the the premise is very good, that there's a defense lawyer who is wronged by one very senior public prosecutor whose mother has been, there is some injustice caused to her, and therefore he decides to become a lawyer. He becomes a defense lawyer. He closely observes how that senior lawyer does his job in the court, and how he what tactics he uses. But there is one particular scene which I must say, which has gone over the board. Now the allegation is that the client of this Mr. Kapoor, Mr. Anil Kapoor, who is shown as the defense lawyer, she's a doctor, and she is accused of administering uh, poison in the form of a medicine to her own patient. Now Anil Kapoor, in a moment of drama, takes that bottle and he tells that, my lord, यही वो bottle है कि जिसमें वो poison था. इसमें poison है ही नहीं. This is not a bottle of poison. And he, with a great flourish, he proceeds to drink that poison. Now it is actually poison, and he goes to the hospital, miraculously he is saved, etc. So the take-home message from this movie is, don't try to emulate such things. This is all fancy drama. Nothing of this actually happens in the court. You have a book called the Evidence Act. Everything happens according to Evidence Act. Every document has to be proved. Every exhibit has to be marked. Everything must come from the proper custody. There is a system of how all these things happen. Of course, that would require another lecture. What is the system, etc. But Meri Jung just came to my mind to tell you what is not to be done. Then we come across some recent movies. Now, Jolly LLB franchise, Jolly LLB 1, Jolly LLB 2, Arshad Varsi and Akshay Kumar. I am discussing these two movies for the simple reason that they are dark comedies. They are a comment on the system. So, if you ignore the procedural flaws, you can really appreciate that movie. This is just not entertainment, it's also a commentary on. Sangeeta Kulkarni has raised a hand. Yes, Sangeeta, you want to ask something? Sangeeta Kulkarni? Are you agreeing with me, or you want to ask something?
Yeah, I am agree with you, and so I raise the hand.
Okay. If you have any questions, please feel free to stop me.
No, the session is going very interestingly,
Thank you.
and I agree with you. Thank you, sir.
Yes. Okay. So we were coming to Jolly LLB 1 and 2. Both are comments on the system. So if you remember Jolly LLB 1, it talked about a hit and run case. Now, this hit and run case actually is heavily inspired from the 1999 famous BMW hit and run case of Sanjeev Nanda. And as students of law, you should go back and read this, Google it. Once you Google it, you will find what the facts are. Once you find what the facts are, you will understand who the parties are. And once you find who the parties are, just go to any site and find out the judgment. It's a wonderful judgment on many issues: circumstantial evidence, law of bail, what is the concept of hit and run, etc., etc. You'll find a wonderful wealth of information. So that movie basically is a large, a very loosely interpreted, inspired by Sanjeev Nanda's hit and run case. Again, it caught my attention for two wrong presentations. I mean, of course, there is so much good about these two movies also, but the not so good part we will discuss. One is that the protagonist files a PIL in the district court. Now, that is something which is procedurally impossible. It is incorrect. So that is something which you should look out for when you watch such movies. It immediately caught my attention because we are used to district courts. I have practiced in both the district court and the high court. So we are used to the setup in district court. We are used to the setup in high court. Here you see him addressing the court as Your Honor, which is normally the appellation which is used in a district court. And your setup is of a district court. The mentioning is of a district court, and he files a PIL, and then there are arguments, etc., which is actually very amusing. Then there is a presentation of a video footage by the defense. At the fag end of the trial, you will find You remember this movie, especially the one that Jolly LLB one I'm talking about. So that is also something which is impermissible. You have a strict code of evidence in how to present video evidence. And if you really understand the law of video evidence, uh, it requires certification under 65B. There are so many things that are also required to go along with the presentation of video evidence. I am not at all saying that videos are not played in courtrooms or in chambers. They are certainly played in, but there is a lot of procedural safeguards that are required to be followed. There is a chronology of events that is required to be maintained. There is a chain of custody that is required to be maintained when these presentations are made. So all that, of course, creative liberty can sacrifice everything else in front of it. But the point is, at the fag end of a trial, presentation of a video footage without following the procedure is absolutely incorrect depiction. Then in my mind, I came across one more movie. I think, a young lawyer when this movie was released. It's a movie called Aitraz. Has anyone heard of Aitraz? It's a movie which stars Akshay Kumar and Kareena Kapoor. The reason
Yes, sir, we have watched it.
yes. So the reason that I wanted to discuss about Aitraz was that it raises a very interesting issue. Normally, what we hear of sexual harassment at the workplace by men against women. Mostly the men are in a dominant position, women are in a subservient position. Here is a classic case which is reverse, where the woman is in a dominant position and the man is in a subservient position, and she takes advantage of him, of this basically this unequal equilibrium that is there, and she tries to force herself on him. And then what is the result? How does the law looks at it? Is there a law which permits such a thing or prohibits such a thing? Is it an offense, etc., etc.? All of these things are there. Of course, again, there is over dramatization. That is the problem with many Hindi films. But according to me, this movie should not be watched for the procedural aspect. It's really worth watching for the subject that it deals with, the topic that it deals with, the theme that it deals with. Now, again, what caught my attention in that movie was the cross-examination of a woman on the point of her character. Now, this is something which is very sensitive and very close to somebody who's a defense lawyer. Even in 2004. Now, of course, now if you look at CRPC, the way it is now, not the new one, not the one which is going to come in on the 1st of July, even the one that we are following as of today, even that one has got so many amendments and so many safeguards which prohibit any kind of badgering of a woman witness, or trying to probe her character, or trying to assail her character and put into question her previous antecedents, etc., etc., to demonstrate that she was either habituated to these kind of things. And again, this concept comes in pink, which I'm going to discuss just for some minutes later. So basically, this was a classic example of how not to cross-examine. So if you look at Aitraz and you go over the cross-examination of Anu Kapoor, I think he was the defense lawyer there. Please note that this is not how you cross-examine on the character of a woman, especially in the case of a women-related offense. Then we come across the famous, I should say, landmark movie, the way we say landmark cases. A landmark movie called Pink in 2016. And there is that famous dialogue, "No means no," which deals with the consent of a woman in a sexual assault case. It's a very sensitive issue. And although, again, this movie must be watched for the theme it deals with the manner in which that theme is dealt with, and again the message, the larger message that is being shown to the society, that when a woman says no, it means no. Again, there are procedural lapses. Now, the procedural lapse, again, somebody might say that I am just doing hair splitting, but there are some procedural lapses in Pink also. One very notable lapse was that Amitabh Bachchan, who is the protagonist, who's the lawyer who's representing the accused lady, is cross-examining his own client. He can examine his own client, but he can't cross-examine his own client. So these are the procedural flaws that are there in Pink also. But please watch Pink, not because of the procedural flaws, but because of the message that it sends. 2019, Section 375, again a very sensitive movie. A movie which left a lot of impact on my mind in 2019 when I saw the movie. I could sense that it is a very well-made movie. Not that it is absolutely perfect and it deals with the procedure in the. See, I'll tell you honestly, if you really look at, if you, me, or all these 84 people in this gathering today, if any one of us decides to make a movie and be a director, obviously we are not going to make a documentary. It has to have an element of human interest. There must be something which engages the audience's mind. So we will take liberties. But my only thing is that in real life, problem is when there is wrong procedure shown. Because young lawyers, when they see such movies, they are tempted to either imitate those false wrong procedures or that wrong attitude or wrong stereotype, and then probably think that this is the correct way of doing things. That is a very big objection or very big issue that I have with these movies. So Section 375, very important film, uh, raises several moral, ethical questions. I think you must watch that movie for those questions also, because if you remember, there's a very famous dialogue in that movie. It says, "We are in the business of law and not justice." Now, of course, I don't agree with this line, and none of us should. But that is, that movie really must be seen to understand why this line is used. Justice, it also says justice is abstract and it deals with the moral dilemmas of a criminal lawyer. So it is something that all criminal lawyers should really watch. It again deals with how media influences people, public opinion at large, and ultimately how it has a percolating effect on the mind of the person who is doing justice, the judge who is doing justice. It all has a percolating effect. And evidence versus justice. Again, a very interesting concept which is presented in that movie. Whether we are looking only at evidence, dry evidence, or do we want to do real justice, where perhaps we might find the evidence not so forthcoming, not so direct, not so convincing, but still there is a desire to do real and complete justice. So very interesting points are raised. 375 is a watch according to me. Please, whenever you have time, please watch it. It's a very good movie. Now I have basically come to the end of discussion on movies. We can discuss movies for years together, and there are many much. Okay, now Anvesha Banerjee has asked a question. Before I answer your question, Anvesha, the question is, I wanted to ask, where did the question go? Anvesha, can you just spell out that question for me, please?
Yes, sir. So I wanted to ask, in most of the movies, it's shown that courts are permitting last minute evidence.
Yes,
So in reality, how much of last minute evidence is permitted?
correct, correct.
Specifically in sensitive cases, is it permitted?
Okay, so I'll take that question, but before that, let me conclude my uh, discussion with some observations. So instead of having a long list of movies, I thought I will sum up with some stereotypes. Now, some of the stereotypes that we typically see in regional movies, Hindi movies, Indian movies is uh, we see lawyers pacing around the court like tigers in a cage and addressing very grand arguments. That may used to happen. I have not seen a jury trial myself, but that could have perhaps happened prior to 1960, but it certainly doesn't happen in any courtroom that I have seen for the last 25 years. Nobody moves around. Actually, the court is so jam-packed. You must go and see a criminal court. The court is so jam-packed that the defense lawyer, poor guy, has a tough time to come to that lectern and address the court. And where do you find the movability where people have can walk around and address the court? So it doesn't happen. Okay, lawyers presenting evidence in any chronology. I think that should take care of your question, Anvesha. Presenting evidence at any chronology, at any stage, and in any manner. So whether it is oral evidence, so we all know what is oral evidence, what is documentary evidence, what is primary evidence, what is secondary evidence. So unless and until these rules are followed, evidence cannot be presented. But yes, if you ask me, as a lawyer who's been practicing in the trial courts for a long time, is there no element of drama in criminal courts? Yes, there is. So let us say at a very end, so when your 313 statement is recorded, your defense evidence is started, and you want to introduce something, there is an element of drama. The court might feel that you are trying to delay the matter, and you will argue and say why it is necessary. So that element of drama, that push and pull is there. but it is not something which is shown in Hindi films. Suddenly some document comes, some photograph comes. Sometimes in many cases I've seen even dead body comes in the court, and yahi aadmi jo mar gaya and all of that. So that doesn't happen. But if you ask me, is there no drama? Any criminal lawyer will tell you that there is enough drama in the court, which is so real and which is really so. Sometimes it really gives you a high. So you really feel good that you are a criminal lawyer. So yes, there is drama, but there is following of procedure to the T. Lawyers becoming investigators. बहुत से time पे we are shown in OTT movies, in movies in which come in cinemas, that they are conducting parallel investigation. अपना खुद का investigation कर रहे हैं. They are sipping coffee and then they are thinking कि अभी इसको क्या करें. We'll go and talk to that witness. We'll go and talk to this witness. If you in real life you go and talk to a witness, what is going to happen? You are going to be prosecuted. Does anyone know the section for which you can be prosecuted? You will be prosecuted in a court of law. The witness simply has to go to the court of law and says that Mr. Chavan approached me in the evening, yesterday evening, and he said that kya ye dekha aapne, wo dekha, ye wo, whatever it is, which relates to the case. It's a straight way of interfering with the administration of criminal justice system. It's simply not permissible. So please don't go and follow these movies and talk to witnesses, talk to people, try to go to that spot and try to change things. You can go to the spot and see the spot. There's no difficulty about it. But can't change things. You can't tamper with the evidence. It doesn't happen. So parallel investigation apne ko nahi karna hai, right? And one eye opener that I can give people is, if you are really fond of trying to emulate these kind of serials, please go to a police station with a client. आपके पास अगर कोई client है जिसको पुलिस केस में जो involved है, go. It's an eye opener for you. Go with him and sit for 2 hours in the police station. You will realize what your rights are. You will realize what your strengths are, and you will realize how criminal law works in practical life. Then you have lawyers not following chronology of evidence, which I just told about. So first you have the examination in chief, then you have the cross examination, and with the permission of the court, you have a possibility of a re-examination. Now in movies, it is all shown haphazard. The lawyer who brings the witness cross-examines him, then suddenly the other side lawyer realizes something, he starts butting in. So it's more of an exchange and rather not a chronology. Then judges beating the gavel. ये बहुत ज़्यादा मैंने देखा है वो ठक ठक, order, and case dismissed, case adjourned. Doesn't happen. Nobody has a gavel. I have not seen a gavel for the last 25 years. So please, rubbish that notion of your head. There is no hatoda or gavel, and he beats the gavel and he says court dismissed or adjourned or whatever it is. That doesn't happen in real life. Cases going on as if it's the only case that the court has got. आप देखोगे Hindi movies में, तो he has got all the time in the world. The judge is sitting only for one case. There is a prosecution, there is defense, and वही चल रहा है. Real life, you go and find out the number of cases that a sessions judge has. Typically, it would be more than 40-50 cases in a day. More, but not less. Out of which some will be bail, some will be revision, some will be appeal. So he has to deal with 80 cases in a day, boss. He can't afford to have just one case and go on and on with it. So sometimes these movies have to come to grips with reality and show even this is drama. See, why this is drama? Because in 10 minutes, in 5 minutes, in 8 minutes, you have to present your best facts to the court and get a result. Is it not drama enough? So if the movie has to be made around a criminal lawyer, perhaps this element can be added to it. Then lawyers manipulating evidence. As I said, parallel investigation करते हैं, evidence को change करते हैं, manipulate करते हैं, and as if they are pulling some cat out of the bag, they will show to the court कि, my lord, this is the evidence that I have got, which is absolutely wrong, which is interfering with the investigation system, which is interfering with the criminal law system. Accused confessing to their crimes and their confessions get accepted in the court. So you have many instances where the accused are confessing at the last minute or somewhere in the middle of a trial, and then the whole dramatic thing, it's like middle of the interval, there is something which is happening, and post interval, you have a situation where the accused suddenly starts confessing. Everybody accepts that confession. Anybody who has understood the law of confession, what is a confession, what are extrajudicial confession, what is a judicial confession, everybody will be amused. If you read the real law, you'll understand how difficult it is for confessions to be proved in the court, how confessions can be retracted. So there's a whole law attached to it and doesn't happen in this way that it is shown. Then no difference between High Court and the trial court, the point that I tried to make in Jolly LLB. Stereotyping defense lawyers and prosecution lawyers. If you really analyze how stereotyping happens, normally defense lawyers are shown to be very smart. They have got all their, everything is in place. They have got a team of lawyers and, they are much more erudite than the prosecution. And the prosecution normally is shown to be very dumb or not very equipped or corrupt. So these stereotypes, these are called stereotypes. These stereotypes unfortunately get attached to lawyers. And the last point that I want to basically end with and throw open for a debate is that in all these films, now before I come to that, there is one interesting observation. If you notice, from 1960 onwards to 2024, a lot of movies on law have been made. Lot of courtroom dramas are there. All these things that I'm discussing about, all of them are there. So, have you noticed a little bit of change? In my opinion, I find that there are two changes. First is that earlier, the judges used to be more silent and they used to be observers and they used to be like umpires, where they used to finally say, all right, you are right or you are right, and this is the verdict that I'm giving. Recently, we find judges entering into dialogue also, where they also start participating in the whole process. They open their mind and they discuss with the lawyers. And another trend that I find is that a lot of activism has also come in, which is good, fine. I'm just commenting on the trends that that are happening today in terms of, and this is happening more because of OTT. See, because of OTT, what has happened? A wider viewership is possible to now be attracted, and since you have number of episodes, there is a recent I think it's a 7-episode thing on Netflix. It is called what is the name? Mamla Legal Hai. Again, a worth watch movie, not because of courtroom tactics, but because it is a very satirical movie. And at the end of that, every episode, you will find that the director or the producer has relied on some paper cutting, newspaper cutting. So he is not talking in air. He has built it up. He has given it a lot of liberty, etc. But he has drawn from real life experiences. So the last point I want to leave you with is the most popular stereotype. क्या है वो stereotype? कि lawyers liars होते हैं, lawyers झूठ बोलते हैं, lawyers dishonest होते हैं, unscrupulous होते हैं. With that point, because I will not comment on that. We are all lawyers. You know, I know, everybody know. What do we do when we represent clients? We are supposed to represent their brief. We are their mouthpiece. We are the connect between them and the court. What they can't say, we are saying. So it is for us to, all of you, to now analyze and tell me whether we are really liars or are we doing our job. With that, I can say that whatever I had to say, I have put across. If there are any questions, if there are any comments, please let me know.
Thank you so much, Chavan sir, for this beautiful and detailed explanation of real versus real criminal trial. So, if anyone wants to ask any question related this, please go ahead. You have 5 minutes.
I'm sorry it went on to 12 o'clock. I'm really sorry to have taken up so much of your Sunday time. But it was so interesting that I couldn't stop myself. Yeah, Ameya has raised his hand. Ameya, yes.
Hello. Yes, sir. Ashish sir, very good lecture. One more movie there is released in December called Nehru, where Laura takes on the challenging case of a blind girl, and he leads story from the prosecution story.
Right. Prakash was discussing about it. It is in my list. But समय मिलेगा तो मैं जरूर देख लूंगा.
Yes, sir. The movie, what about Nehru is its focus on the legalities and the complexities of the law.
Okay,
The movie, very nice movie, sir.
certainly. Thank you so much, Amay.
Yes, sir.
Anybody else? Yes, Smita Chavan has raised her hand. Ask me, madam.
Sir, generally we can see nowadays there are the reel on YouTube or like a media trial. So please enlighten us on that media trial because so many trials are happening outside the court only nowadays. So what about that?
See, there is really uh, very little that is actually there for comment on this. Because one thing we must understand that media is the fourth pillar. Media is here to stay. Media is not going to go anywhere. Media has a right to comment about everything and anything. Whether it should exercise that right in a manner which should show some restraint or not is something which they have to introspect. We can't really have laws to gag the media or to stop the media from representing. A classic case I will just share since this issue is come up of media trials. Recently, there is this documentary drama or docudrama, as they popularly call it, on Sheena Bora murder case. Now, Sheena Bora murder case is a sub judice case. In fact, I was part of the team which was part of the CBI prosecution, which opposed this entire thing in the High Court. And the High Court saw this particular docudrama. We also saw it, the drama. Our argument mostly was that this would prejudice the people's mind. But then, what was ultimately came out of it was that all the material that was shown in that docudrama was already in the public domain. So the argument was that whatever is in the public domain can't really influence or prejudice the mind of the court. So these are the kind of issues that one faces. Media trials are, I think, a part of life now. I think we should, instead of trying to curb media trials by the use of law, I think we should all become more mature and look at the facts and not what is being reported in the media. That is how I would like to answer that question.
सर,
Yes.
क्राईम पेट्रोल सारख्या सिरियल्सने क्रिमिनलला काही मदत होत असेल का?
हे अनएंडिंग प्रश्न आहे. म्हणजे मूवी वाचून कोणी मूवी बघून कोणी क्राईम करतो का, की क्राईम केल्यानंतर जे घडतं त्याचं डिपिक्शन मूवी दाखवतं. म्हणजे इज मूवी अ मिरर ऑफ सोसायटी और व्हॉट एव्हर इज हॅपनिंग इन सोसायटी इज बिकॉज ऑफ मूवी. हा एक विच इज अ चिकन फर्स्ट और हेन फर्स्ट, तो अंड पहिलं की कोंबडी पहिली, असा हा प्रश्न आहे. त्याला काही तसं सॅटिस्फॅक्टरी आन्सर, माझं ओपिनियन जर विचारलं वैयक्तिक, तर ते असं आहे की मीडियाने सेल्फ रेग्युलेशन करावं, सेल्फ रिस्ट्रेंट ठेवावी. कारण मीडियाच्या हातामध्ये ओपिनियन मेकिंगचं खूप मोठं शस्त्र आहे आणि ते शस्त्र किंवा ती गोष्ट, ते टूल त्यांनी कसं वापरावं हे कुठेतरी त्यांनीच ठरवलं पाहिजे. कारण जर याच्यावरती काही नियमावली आली तर उद्या परत हे म्हटलं जाईल की फ्रीडम ऑफ एक्सप्रेशनवर घाला आला. त्याच्यामुळे कुठेतरी याच्यामध्ये लिगल उत्तर शोधण्यापेक्षा असं मला वाटतं की लोकांनी याच्यावरती एवढा प्रोटेस्ट केली पाहिजे, संस्थांनी म्हणा, लोकांनी, जागरूक नागरिकांनी म्हणा, की त्यांना, त्या प्रोड्युसर्सना डिसइन्सेंटिव्हाइज झालं पाहिजे की नाही, हे बनवून काही उपयोग नाही, लोक बघणार नाही, लोकांना इंटरेस्ट नाही. जेव्हा लोकांचा इंटरेस्ट निघून जातो तेव्हा आपोआप ती गोष्ट मरते, असं माझं वैयक्तिक मत आहे. विवेक, येस.
Sir, my question is, how should a layman approach such movies which are depicting the courtroom dramas or showing the courtroom proceedings? Because they are not someone who is aware of the statutes or the law which shows these courtroom proceedings. So now, has you discussed in this entire session that this movie is showing this, Nanavati is showing jury trials? So you pointed out exactly what the lacunas were in these movies. But how should a layman approach to these movies? How should he receive? How should he see that movies?
Actually, we are all not laymen. All of us are lawyers. So difficult for me to understand the question because I am not a layman. But I would say this, that a layman should approach it from the same perspective that he approaches any other film. See, look at movies. Politicians are stereotyped. You agree with me? Not all politicians are corrupt, right? But largely they are shown to be corrupt. Largely they are shown to be arrogant. Largely they are shown to be XYZ. Uh, there was a time when our Sikh brothers used to be shown as car mechanics. कोई भी सरदार जी होगा तो वो कार मैकेनिक है, ये स्टीरियोटाइप हुआ करता था. तो ये स्टीरियोटाइप्स धीरे धीरे लोगों को पत्या काम वाली बाई है वो गंगूबाई है. These are the stereotypes which start from media, and they get perpetuated in society. But at some point of time, people realize that these are only stereotypes. करेक्ट. सो कहीं ना कहीं लेमैन को भी ये रियलाइज होगा कि ये ठीक है, मैं जाके 3 घंटे देखता हूँ, आनंद लेता हूँ, हंसता हूँ, रोता हूँ, वॉट एवर इट इज, एंड देन फाइनली व्हेन आई कम बैक आई रियलाइज कि अगर मेरी केस है तो ऐसा कुछ होने वाला नहीं है उसमें. If there are no more questions, then we can wind up.
येस. श्रुती.
येस सर. सर, सर्वात प्रथम मी तुमचा आभार मानू इच्छिते की तुम्ही आम्हाला संडेच्या दिवशी सुद्धा वेळ देऊन इतक्या छान पद्धतीने रिअल लाईफ आणि रिअल लाईफ क्रिमिनल ट्रायल्स बद्दल मार्गदर्शन केलेलं आहे. आता वेळ झालेली आहे आपल्या आभार प्रदर्शनाची. तर मी ॲडव्होकेट अजय खैरवार सरांना आभार मानण्यासाठी आमंत्रित करू इच्छिते. अजय सर.
Hello, sir. Hello, everyone. Sir, myself, Advocate Ajay Khairnar. I would like to myself, sir, on behalf of all of here today, I would like to express our sincere gratitude to Advocate Ashish Chavan, sir, for taking the time to deliver such insightful lecture on behalf on judging reality, real versus real criminal trial. Sir, your presentation was truly enlightening and knowledgeable. We are here honored to have you with such extensive knowledge and experience that you shared in the field of litigation. Sir, thank you for making a time from busy schedule and sharing insights with us. I would further like to extend my heartfelt gratitude to our anchor and our volunteers who have worked effortlessly to make this event success. I would also like to thank all of the participants who took the time to join us today. Your active participation and engagement in this session has made it even more worthwhile. Once again, thanks to all who were involved, and we look forward to such more future events. Thank you, sir. Thank you so much, all of you, for joining.